We are now moving on to the case of Bribriesco-Ledger versus Klipsch. Let's do a quick sound check. We'll start with, is it Brett or Brent?
Brett, Your Honor, 2 T's.
Okay, thank you. I think it originally said Brent. We just got it fixed. Thank you very much.
You.
Brett Marshall, and I can hear you, and you can obviously hear me. Thank you very much. Now I'll move to Mr. Meloy. Can you hear me?
Yes, I can. Justice.
Thank you. Okay, thank you. You may begin your argument, Mr. Meloy. Oh, did I name the wrong one here?
Yes,
I sure did. It should be Mr. Marshall. Excuse me. Mr. Marshall, you can begin.
Thank you. I'd be happy to let Mr. Meloy go first.
No problem. Sorry about that.
Mr. Meloy, Chief Justice, Honorable Justices, and may it please the court. My name is Brett Marshall. I'm with the law firm of Lane and Waterman, and I represent the city of Davenport and Frank Klipsch in his capacity as the former mayor of the city of Davenport. This case comes to the court on a denial by the district court of a motion for summary judgment by the defendants. And it's really a kind of a peculiar case because the facts as they relate to the city's and the mayor's removal of the plaintiff as a commissioner from the Civil Rights Commission are undisputed. It's undisputed that the mayor followed the provisions of 372.15 when he removed the plaintiff. However, the district court found a fact issue because it imputed a for-cause requirement to remove a local civil rights commissioner. And that imputation comes from Iowa Code 216.19.2, which authorizes the formation of a local civil rights commission. And the district court relied on the word independent in that statute to imply a for-cause requirement under 372.15. Now, this case is purely one of statutory construction and interpretation. We would argue the law with regard to 372.15 is clear, and it's been clear for 100 years. So under Iowa Code 372.15, an individual who appoints a city officer has the authority to remove that city officer by sending a letter to the city officer stating the reasons for the removal, by sending it certified mail, by filing a copy of that letter in the clerk's office, in the city clerk's office, and by informing the plaintiff or the individual being removed that they have the right to a public hearing. And there's no dispute in this case that all those things happened. In April of 2019, Mayor Klipsch sent a letter.
Counsel, that may be true, but the real question in my mind is whether the Davenport Civil Rights Commission is an independent commission if the mayor can replace commissioners without cause. Ordinarily, when you think of the term independent, you think of free from political influence. There are independent federal commissions and so forth. But if the mayor can terminate someone so quickly, I just think that gives a real question of whether there's independence here.
Well, I guess, Your Honor, to answer your question, that assumes what the legislature meant by using the word independent in 216.19.2. And the problem with the district court and the plaintiff's argument there is that they fail to engage in the norms of statutory construction when answering that question. So we have two parallel statutes with parallel authority, two state statutes. We have 372.15 and we have 216.19.2. Now, the job of the court is to, if they think that there's a conflict, is they first have to decide whether there's a conflict between the two statutes. And there can only be a conflict when the statutes govern the same subject matter. And it's our position that the statutes here don't govern the same subject matter. If you look at 372.15, it specifically addresses removal of city officers. It's not specific to a local civil rights commission. It's very broad in its scope. And then you look at 216.19.2, which authorizes the creation of a local civil rights commission. They don't address, there's no language in 216.19.2 that addresses the removal of any local civil rights commissioners or
Mr.
any
Marshall,
state commissioners.
This is Justice McDonald. 372.15 also provides, I believe, that the appointing officer has a removal authority unless otherwise provided for by state law. And so it's not necessarily an issue of conflict, but I think the issue is implicit in the word independent, some sort of limitation on the ability to remove these commissioners. And I guess I'd like you to address that question independently. So if you were just interpreting the Civil Rights Commission statute by itself, what does the word independent mean?
Sure, I'll address that. I'll first start off by saying that it's the court's role when interpreting the statutes to avoid a conflict, right? So that's where we first have to start off. But in terms of what the legislature meant by the word independent, the plaintiff and the district court said, well, it has to mean in like an independent agency, and that's why they cite to these federal cases, that it has to be similar to the SEC or the FTC or those kind of administrative agencies. Well, in Humphrey's Executor, which was the U.S. Supreme Court case that kind of identified what the hallmarks of an independent agency are, the U.S. Supreme Court identified two hallmarks. One is that the commissioners or the members of the board be appointed for a fixed term. And the second is that the enabling statute of that board or commission has a for-cause removal standard written into the statute. So the way that the plaintiff and the district court is interpreting the word independent here, by reference to the federal cases, puts the cart before the horse. It's not the word independent that establishes for-cause removal standards. In fact, I'm not aware of any law, whether state law or federal law, that says use of the word independent imputes a for-cause removal standard for an independent agency. It's
Counsel, if I may, what does that word mean in 216.19 sub 2? What does independent mean as used in that sentence?
Well, we've offered two reasonable interpretations of what independent means. The first is that it means independent from the state Civil Rights Commission. And the reason that makes sense is because if you go on in 372.15, the legislature talks about the need for cooperation between the state commission and the local Civil Rights Commission. It's through 372.15 and 372.16. And so when they say it has to be independent.
Well, Counsel, if I might push back on that, the next word after independent is local. So wouldn't that be repetitive of local if it means not state?
No, I guess I don't read it that way, Your Honor. I read it, an independent local agency. Again, the hallmarks of independence, if we're going to rely on the cases and what the federal courts have interpreted as an independent agency, means boards and commissioners appointed for a fixed term, and then for-cause removal language in the enabling statute. We don't have that in this case. We don't have an enabling statute that contains for-cause removal language. So it would be hard to then say, well, this is similar to the federal independent agencies like the FTC or the SEC, whose enabling statutes specifically say members and commissioners can't be removed for cause.
Let me go at that from a somewhat different angle, Mr. Marshall. All right, 1965, we have the Iowa Civil Rights Act is passed, and it sets up a state commission with members that can only be removed for cause by the governor. At this point, there aren't local civil rights commissions. 1990, the legislature says, well, in larger communities like Davenport, let's go ahead and have local civil rights commissions, and let's provide that they'll be, quote, independent. Isn't it logical to conclude that by that word independent, the legislature meant, well, they should have that same characteristic that the state commission has, since they're going to be taking over some of the work of the state commission in those communities?
Well, Your Honor, I would say that, again, we would have to assume that what the legislature meant by using the word independent was that they meant that commissioners could only be removed for cause. And I think that's a stress. When we interpret statutes, we're not to read into the language of the statute, right? We're to read the statute as written if it's unambiguous. Now, if we're going to say independent is ambiguous, there has to be a reasonable alternative interpretation. And
Sir, Mr. Marshall, if we were to buy that argument, does it make sense that the Davenport Civil Rights Commission then would serve at the pleasure of the mayor?
No, as we've pointed out in our briefing, independent, the local Civil Rights Commission can still be independent, although the commissioner is subject to the mayor's removal power. And we've listed a number of ways in which the local Civil Rights Commission is still independent. It manages its own staff. The mayor and the city council doesn't have any authority over the commission staff. The commission has authority over staff. The commission decides which cases to hear and which cases to prosecute. The commission can appoint attorneys to represent it and can bring claims. And so there are a lot of hallmarks that the commission has, which it allows it to retain its independence, but still be subject to a mayor's power to remove an appointee, his own appointee, I would add.
Mr. Marshall, the DCRC's authority includes also policing the city itself. Is that correct?
With regard to civil rights claims.
Correct. So could the mayor, if the DCRC was investigating a civil rights complaint against the city itself, could the mayor remove the commissioners and appoint new commissioners to the commission? And I understand there may be Iowa civil rights type claims, but just in terms of the removal statute, I take it your interpretation is the mayor could remove the commissioners for any reason whatsoever, including the attempt to thwart an investigation. Is that fair?
Well, I would say, I mean, in a simple term, yes. But of course, if the motive for the removal was to thwart the investigation, that could be raised certainly by the commission. Again, they're allowed to appoint an attorney to represent them, and they could raise those issues in court. But with regard to the authority of the mayor, again, the mayor proceeded under 372.15, and this court for the last 100 years has stated that no cause is required. Now, if we're going to go to unless otherwise stated by law, and we're going to say that 216.192 is that other law that provides otherwise, I would say that we can't read into the legislator's intent when they use the word independent to require for cause removal. They know how to do that.
Counsel, on that point, are you aware of any other instance in the entirety of the Iowa Code where independent has been read or would be read to mean for cause firing?
No. And I'm not aware of any cases that interpret the word independent to mean for cause requirement, whether it's state or federal law. I have to say that the
Mr.
state.
Marshall, can I ask you a follow-up question to that?
Sure.
Imagine a counterfactual if you had the same statute, but with the word independent removed. How would the statute be different in operation with respect to this local civil rights commission? I mean, it seems to me you're giving no meaning to the word independent.
No, again, I think independent means independent from the state agency. If you'll recall that there's also a numerical requirement in the code that says cities with populations over 29,000 are required to establish an independent local commission. Well, if we're going to say that independent has the meaning ascribed to it by the district court and by the plaintiff in this case, then it's saying that if a city or town underneath 29,000 decides to establish a civil rights commission, it doesn't need to be independent. Well, that doesn't make sense because we would want the same commission, regardless of population, to mean that it's free from political influence. But I don't think that's what the legislature intended. And again, I'll go back to this idea that the legislature knows how to write in for cause removal standards. In 414, chapter 414.8, regarding with boards of adjustment, the state legislature authorized cities and municipalities to form local boards of adjustment. And in that statute, the legislature chose specifically to say members of the Board of Adjustment cannot be removed except for cause. Likewise, in chapter 441.4, the state legislature did the same thing with regard to boards of review. It authorized the establishment of local boards of review, but it specifically included in the statute language that those members of the board could only be removed for cause. We could say the same thing about the Civil Service Commission under 341A, or the Board of Health under 331.321. The legislature knows how to include a for-cause removal standard, and they didn't do it in this case. We would ask that the court reverse the district court's decision, denial of the motion for summary judgment, grant the motion, and dismiss the case.
Thank you, Mr. Marshall. Mr. Meloy, you may proceed.
Thank you, Justice. Defense counsel's argument essentially comes down to this. He claims that the mayor can remove a commissioner anytime, any place, for any reason. That particular interpretation of section 216.19 of the code defies the clear meaning of the word independent as used in that statute. The legislature approved this statute initially back in 1965, establishing a Civil Rights Commission. Counsel's argument basically says independent means nothing. Black's Law Dictionary defines the word independent as free of outside control and outside influence. The critical element of the word independent is reasonably implied protection against removal of a civil rights commissioner except for cause. Now, you heard the argument that defense counsel made that the word independent as used in 216.19 supposedly refers to the fact that the local Civil Rights Commission is independent from the state Civil Rights Commission. That argument doesn't hold water. While that is true that the local Civil Rights Commission is independent and separate from the state commission, that does not mean that the legal analysis of the interpretation of the words independent local Civil Rights Commission or agency in section 216.19 stops there. The court must read.
Counsel, if I may, counsel, I happen to have Black's Law Dictionary right here. You read the first definition under independent, but the second one is not associated with another, often larger entity. Couldn't we read independent to mean that it's not associated directly with the state or even with the local? In other words, it's not a municipal agency, it's independent of the city itself, which would then give it a different meaning from the word local, which immediately follows it.
Well, I'm not quite sure what you're asking there, Justice, but I'll try to answer it. I believe that the commission is a separate and autonomous commission from the city of Davenport. The section 216.19 mandates that the city had to create the local Civil Rights Commission. And there's a reason for that, because the commission protects persons from being discriminated against on the basis of race, sex, sexual orientation, gender identity, national origin, religion, creed, color, disability, age, and marital status.
Right, and I'm sorry, what I'm getting at, counsel, is it says in 216.19 sub 2, shall maintain an independent local civil rights agency. Couldn't independent, as used in that sentence, mean separate from the state and separate from the city? In other words, it's not a city agency, it's separate from the city itself.
Yes, I believe it can be construed to be separate from the city. This is a separate independent civil rights commission, and I believe as Justice Mansfield or Justice McDonald touched on earlier, this commission would have the ability to investigate a complaint made against the city of Davenport, the mayor, the alderman, or its employees if there was a discrimination complaint made under the ordinance. So therefore, there is a separate independence by the commission from the municipal local government.
Mr. Meloy, this is Justice McDonald. Why should we read a for-cause requirement into the word independent when the same statute explicitly provides for cause protection for state commissioners? To me, it would seem like that would indicate that if the legislature wanted to have the same protection, it certainly knew how to do that and could have done it very easily.
Well, first of all, I believe these two sections of the code involving state civil rights commissioners and local civil rights commissioners were adopted by different legislatures at different periods of time. The state commission was adopted first, and the local commission statute 21619 came after that. And the district court dealt with that issue, Justice, in the district court's ruling, and said that logically, because a state civil rights commissioner is independent and can only be removed by the governor for cause, this should also apply to a local civil rights commissioner, because otherwise the word commission does not have any rational meaning in relationship to the city and the mayor.
Mr. Meloy, this is Justice Oxley. I want to ask you the same thing that Justice McDermott asked your opposing counsel. Are you aware of any other instances where independent has been read to require for cause, or can you identify even in any kind of agency enabling act that does not have an express for cause requirement, but yet that for cause requirement has been imposed?
I'm not aware of any other statute that uses the word independent as the word is used in section 216.19. So I don't believe there is another statute comparable to section 216.19.
Mr. Meloy, this is Ed Mansfield. Can I ask you about some other language in 216.19 too? In addition to the requirement of an independent local civil rights agency or commission, the statute says an agency or commission for which a staff is provided shall have control over such staff. That's a pretty specific statement. And it strikes me that if your broad view of what independence means is correct, that specific statement wouldn't be needed, would it?
I disagree, Justice. I believe that specific statement, an agency or commission for which staff is provided shall have control over such staff, means that the local civil rights commission has control over the local civil rights staff and its operations. And that, therefore, that's a logical extension of the word independent used in the first sentence, because not only is the commission independent from the control of the city of Davenport, its staff is also independent and under the control of the actual 7-member Civil Rights Commission. Now, you heard that counsel claim that 372.15 of the Iowa Code controls this case. We believe it 372.15 does not control the case. The key words in 372.15 that distinguish this case, this removal, from other removals under 372.16 are the words "except as otherwise provided by state or city law." Going back to 216.19, that code section, by the use of the words "an independent local civil rights agency," controls over the general statute of 372.15. Additionally, section 216.19 was adopted by the legislature after the enactment of section 372.15. So it's a statute more sooner in time relative to the older statute of 372.15.
Mr. Meloy, this is Justice McDonald. Can you address directly the Scott case? And to me, that seems like it would be a more compelling case for finding a for-cause requirement, maybe than this case. So could you address that directly, and what bearing does it have on our determination here?
Yes, I believe the Scott case involved the city or the police chief removing a police matron from her job. And that case determined that the matron, the police matron in that case, did not have the right to her job because the mayor did not have to state any reason for her removal. This case presently can be distinguished from Scott by the fact that there's a specific statute passed by the legislature governing civil rights commissions under Chapter 216 of the Iowa Code. Additionally, what we're dealing with.
But I guess my question is in Scott, there was also a statutory provision that said the police matron was entitled to the position during good behavior, which seems like a fairly explicit for-cause kind of burden. And our court disagreed with that. That's been the law for a long period of time. And the legislature enacts this statute against a backdrop of that case law. So can you help me with that issue of how it bears here?
Well, I think, as I said, that Chapter 216 of the Civil Rights Act is a clear enunciation of the legislature's enactment of civil rights law. And in the Scott case, there was no language similar to what we have here. As I mentioned earlier to the earlier question by the justices, that I wasn't aware of another statute that used the word independent as it's used in section 216.19. And so in Scott, there was no statutory language except for those words that you cited in the statute. And I think that can be distinguished from the present case because you have a statute that was specifically passed by the legislature for the independence of local civil rights commissioners.
So I take it then,
judicial authority.
I take it then your position is the word independent has a stronger for-cause meaning than the term for good behavior that was at issue in the Scott case.
Yes, I think that's a fair statement, Justice.
Okay.
I think the word independent has a stronger statutory meaning than the words used in the police matron case, the Scott case. Now, the district court in its ruling analogized the independence of the Civil Rights Commission under both federal case law, United States Supreme Court case law, and found that under the leading seminal case of Humphrey, decided by the United States Supreme Court in 1935, that a Civil Rights Commission should have independence from the executive branch. And the district court found there was an implied standard of cause for removal based upon the 1935 United States Supreme Court case of Humphrey's executor, and also cited other federal case law in that regard. And I think this court should turn to the federal case law, United States Supreme Court case law on removal of independent commissioners regarding that there must be a for-cause statute to do so beforehand. The Civil Rights Commission has contractual power to make contracts with the State Civil Rights Commission. It has investigatory power. It has the power to issue subpoenas. It has the power to award damages in contested cases and to award attorney fees. Of course, there's appellate review in the district court on any commission contested case finding. They issue written decisions, and
You may wrap up your argument, Mr. Meloy.
and they make conciliation agreements. I would request that the Supreme Court affirm the district court's denial of summary judgment in this case and remand the case back to the trial court. Thank you, Justices.
Thank you. Mr. Marshall?
Thank you, Your Honor. I'm thankful to Mr. Meloy. At the end there, he just pointed out to you how the local Civil Rights Commission, the number of ways that they can remain independent while still being subject to the mayor's removal authority. I would like to point out—
Counsel, would we be independent judges if we could be removed by the governor without cause?
I would have to answer yes to that question. And I would also say that I guess that depends upon what statute we would be interpreting that requires that you be independent, which is the very case here. We can't pull out of whole cloth the meaning of independent that we want to ascribe to the statute based on a policy justification. It's not the court's job.
But the whole history of the Iowa Civil Rights Act, I mean, it goes back, as Justice Mansfield was saying, 1965. These Civil Rights Acts were controversial at first. There was concern that major employers would be sued and labor unions would be sued. In fact, that's exactly what happened. I mean, in Iowa here, we had major employers and labor unions sued and so forth. The desire was to create a commission that would be free from political influence to handle these kind of matters, not structure a commission to inject politics into their decision making. Am I missing something?
No, I understand the policy concern, Your Honor. But again, the court's job is not to write policy. That's for the legislature to determine. Our job is to interpret the statute. And as Judge McDonald pointed out, this has been on the books. 372.15 has been on the books since 1920. And the State Civil Rights Act 216 has been on the books since 1965. And in 1965, the legislature specifically included a for-cause removal requirement for state commissioners. It would seem odd, given that they know how to do it, that they would choose to give that same protection to local civil rights commissioners by using the word independent, as opposed to using the for-cause removal language that they did for state commissioners.
So
And I'd also,
your view would be the legislature thought that local politics, intervention by local political leaders into Civil Rights Commission proceedings was appropriate and fine.
well, I don't know what the legislature thought. All I know is what the statutes say.
Well,
And
yeah, go ahead.
what the statutes provide is no cause. That's what the statute provides. And the legislature is presumed, I go back to Mr. Meloy's argument when asked about the differences. Well, why did the state grant for cause removal for state commissioners and not for local commissioners using the same language? And the answer was, well, it was different legislatures, different periods of time. Well, again, our canons of interpretation and construction tell us that legislatures are presumed to know what the law is. And the legislature knew under 372.15 since 1920 that there was no limitation under 372.15. And if they wanted to provide the protections that they provided to state commissioners, they could have done that, and they didn't. With regard to Judge McDermott's reading of the second definition on Black's Law definition of independent, that's also another separate, interpretation that we give in our briefing to the word independent. Not only did we say it's independent from the state agency, but an alternative is that it's independent from the city, which Mr. Meloy certainly recognized that's a possible interpretation. And again, when it comes to our canons of statutory construction, that's the interpretation that the court should use, because that's the interpretation that gives meaning to both statutes, that harmonizes the two statutes together, and avoids a conflict. We're supposed to interpret statutes to avoid a conflict. And I think the interpretation that we give to the meaning independent, or to the word independent, satisfies all of those canons of statutory interpretation, and it avoids, following those canons avoids the very problem that we ran into in this case, which is where we have courts rewriting statutes under the guise of judicial or statutory construction and interpretation. And it would be our position, again, that there are no facts at issue here, and the court should find that motion for summary judgment was improperly denied and should grant the motion and dismiss the case. Thank you.
Thank you, Mr. Marshall. The case of Bribriesco-Ledger versus Klipsch is hereby submitted. The court will take a 15-minute recess. It is 10:21 right now, so at about 10:40, we will resume back in session. So at this time, court is adjourned briefly.